Tim Stanger. I'm the co-chair of the Holland and Hart Healthcare Group, and welcome to our latest edition of our legal update for the healthcare industry, hopefully summarizing some of the legal developments that have occurred in this COVID-19 pandemic. I'm joined today by my colleagues, Christy Kimball, Brad Cave, and Jay DeVoy. We've each got different aspects of legal issues that have occurred over the past week. It has been an eventful week, culminating in a surprise visit from the Easter Bunny and or HHS that you may have seen a deposit into your accounts. I'll talk more about that a little bit later. To start out with, we'll turn the time over to Brad. Brad will be followed by Jay, then Christy, then I'll come back and talk about the $30 billion that was sent out over this past week. Brad?
Thank you, Kim, and good afternoon to all of you. Thanks for continuing to be a part of these webinars. I'm going to spend just a few minutes today to bring you up to date on a couple of changes to the Family First Coronavirus Response Act, particularly as it pertains to paid leave in the use of employer paid leave concurrently with the leave provided under the Act, and to talk about some new Q&As that the Equal Employment Opportunity Commission published as well. So first of all, the Family First Coronavirus Response Act. Those of you that have been playing along at home know that there are two kinds of leave under that act. There is the expanded family and medical leave and paid sick leave. There has been a lot of confusion over how employer-provided leave can work with or run concurrently with the leave under the Family First Act. Originally, the DOL's Q&As were pretty restrictive, and in fact, there were three questions, 31, 32, and 33, in the DOL's Q&As that addressed this topic. Then a week ago, we talked about the new regulations that DOL had adopted, the temporary rule implementing the extended family and medical leave and the expanded family medical leave and the paid sick leave act. Those regulations had another provision that contradicted the DOL's Q&As, which really sowed a lot of confusion for employers. Well, so on Friday, the DOL issued some corrections to their regulations. They deleted the section that caused all the confusion, and they changed the answers to Q&As 31, 32, 33 to address this issue. So I'm going to summarize these. You can go to the DOL website and look at the Q&As if you want to ponder over these at a different pace. So under the expanded FMLA leave, and this is the leave that occurs only when the kid is home from school or from daycare, and school is closed or child care is unavailable. For the first 2 weeks of that expanded FMLA leave, the employee is entitled to use their paid sick leave under the Paid Sick Leave Act, and the employer and the employee can agree to supplement that amount from the Paid Sick Leave Act with employer-provided leave under your policies. So that's the first 2 weeks there under the expanded Family and Medical Leave Act. For the next 10 weeks under that act, the employer can require, it's a change. In the first 2 weeks, the employer could not require. In the next 10 weeks, the employer can require the employee to supplement or take employer-provided paid leave in addition to the extended or expanded family and medical leave for that 10-week period. The employee can also elect to do so if the employer does not require them to do so. So in this situation, this would be an option for an employer when they have very generous paid leave policies, when they obviously want to avoid the result of the employee taking several weeks off to take care of their child, and then as soon as things return to normal, as soon as the kid, summer break comes, the kid goes on to something else, then the employee wants to use paid leave for vacation, for instance. So the employer can require for that 10-week period. This is limited, however, that the employer can only require the employee to use accrued paid leave that would be available under the employer's policies for this particular reason, for the child being home because of school being closed. And that would normally limit this to paid time off, that where it's defined as using paid time off for any reason the employee chooses to. You may have some other kinds of leave that the employee can use that do not require illness. The Q&A say specifically that this would not include medical or sick leave if the parent is not ill or the child is not ill. So you can use paid time off or personal leave, but not sick leave for this 10-week period because nobody's home ill. On the Paid Sick Leave Act front, basically the same rules apply for that 2-week period where there are multiple reasons for the leave. You cannot require them to take existing leave concurrently, but if the employer and the employee agree, you can supplement the wage that they would otherwise receive for that leave period with paid accrued leave. Under both circumstances, the employer's tax credits are limited to whatever the employee would have received under the formula provided in the Family First Act. The other significant change in the corrections published on Friday was just a clarification that that the employee only gets 12 weeks of expanded Family Medical Leave Act, even if that 12-week period even if that 12-week period runs over 2 of the 12-month traditional FMLA periods that the employer has established by policy. Under traditional FMLA, your 12-week allotment is counted on a 12-month basis, and employers have some options for how to define that 12-month basis. This change on Friday, or this clarification on Friday, simply said that no matter what the employer's 12-month basis, no matter if we move from one employer 12-month year to the next employer defined 12-month year, under their old FMLA policy, employees only get 12 weeks total of expanded Family Medical Leave Act. So that was a good clarification to avoid kind of doubling up on that or taking additional. So moving to the Equal Employment Opportunity Commission Q&As. These were updated on Thursday, and there have been some prior Q&As that have come out that were actually quite helpful to healthcare employers in particular, that provided some clear guidance and some flexible guidance for screening employees for COVID-19 symptoms. The new Q&As address that topic in a little more detail. They allow employers to continue to screen employees for COVID-19 related symptoms. So you can take employees' temperatures when they arrive at work, you can ask about related symptoms, and you can ask about the scope of symptoms that the CDC or other public health authorities have identified as perhaps being associated with COVID-19. So where we started out with fever, cough, and shortness of breath, the EEOC now indicates that some public health authorities, and maybe the CDC is saying this too, that there might be loss of smell or taste, and perhaps gastrointestinal problems such as nausea, diarrhea, or vomiting. So they essentially expanded the permissible questions that employers can ask as far as screening employees when they come to work or screening them periodically. The EEOC also advised that employers can keep a log of the information they gather through these screenings, including temperature information, so that they can look for any trends when it comes to that. But they must maintain that as they must maintain that log as a confidential medical record, just as they would under the Americans with Disabilities Act or the Family and Medical Leave Act. The data about each employee can be aggregated in a log, but that log has to be limited by those statutes and how it can be used. The rest of the Q&A from the EEOC was really directed toward ensuring employers are complying with their accommodation obligations under the Americans with Disabilities Act. And their anti-discrimination obligations. One Q&A made it very clear that an employer cannot make an employment decision about a person because they're over the age of 65 or because they're pregnant based on those conditions, and either deny them a position or delay a start date for a new employee because of COVID-19 concerns. The Q&A said that they can talk about that with the applicant and try to reach an agreement about a postponed start date, but they cannot discriminate on the basis of age or on the basis of pregnancy to delay or change the terms and conditions of employment because of COVID-19 concerns. So as I read that and interpret that in the context of the ADA, you have to have something more than age and or pregnancy. You have to have a diagnosis of some prior condition that compromises the immune system or something in addition to being pregnant or being over 65 that gives the employer more latitude to require the employee to change how they do the job or to otherwise protect themselves from COVID infection. The accommodation issues that the EEOC addressed really boil down to the idea that COVID-19 may create new requirements for accommodation of employee disabilities. Those disabilities prior to COVID-19 may not have required any accommodation or may have required accommodation of one sort, and because of the enhanced risk or the enhanced concern because of COVID-19, the accommodations may change or they may be expanded for the period of the pandemic. There may be new accommodations that might be required for doing that. So COVID-19 might change the character of the employee's disability or how it impacts their ability to do the essential functions of the job, and the employer has to engage in that interactive process to explore what accommodations can keep the employee home at work and allow the employee to continue to perform the essential functions safely. This includes when the employee feels like they need to self-quarantine because their underlying disability makes them more susceptible to COVID-19. The employer has an obligation in that situation, even without symptoms or without a diagnosis. The employer has the obligation to engage in the interactive process through which the employer can obtain medical information, consider whether there are other accommodations that would allow the employee to remain at work, and essentially follow the same interactive process you would without COVID-19, but with the new COVID-19 overlay. So those are the key aspects from the EEOC and the DOL. With that, I'm going to turn it over to Jay.
Thanks, Brad. I'm just going to speak briefly about some developments from the Office for Civil Rights within the Department of Health and Human Services. When last we spoke, there was some discussion about Section 1557 of the Affordable Care Act, which imports several civil rights laws that were enacted by Congress many, many years ago and applicable to many other relationships such as in education and employment, and imports them into the healthcare context and extends them to any entity or program that receives funding or participates in programs that are put on by the Department of Health and Human Services. It was in the news that the Office for Civil Rights had pursued an action against the state of Alabama in connection with its 2010 guidelines for the use of ventilators. When OCR had first made its statement about the enforcement of Section 1557, it indicated that the triage and the apportionment of healthcare resources in response to COVID-19 needed to take into account civil rights laws and ensure that they did not discriminate against any kind of recipients on the basis of age, race, or disability. There was a complaint filed with the Office for Civil Rights against the state of Alabama in connection with guidelines that the state of Alabama had published in 2010. It's unclear based on the publicly available records whether these 2010 guidelines that were adopted by the state of Alabama predate or postdate the passage of the Affordable Care Act. But nonetheless, these records from the state of Alabama and these protocols were still available online. It was not clear whether or not they were still going to be enforced by the state of Alabama or if they were still in effect. So based on this complaint, the Office for Civil Rights took action and investigated this matter with respect to the state of Alabama, basically inquiring whether or not these were effective, especially in light of the crisis guidelines that have been published by the state of Alabama in 2020. Specifically, these crisis standards of care were introduced by the state of Alabama on February 28, 2020, and since then, numerous other states have implemented, updated, or released their own crisis standards of care for response to COVID-19. What was not clear from the February 28, 2020 crisis standards of care that the state of Alabama had published, however, was whether these 2010 guidelines for the use of ventilators were still in effect and would be given any effect in the use of ventilators in response to the COVID-19 emergency. So what the Office for Civil Rights did in the course of its investigation and part of the resolution of it, which should be a public document and should be available through FOIA at some point in the future, but has not yet been released by the Office for Civil Rights. What happened with that resolution was the state of Alabama was forced to remove any web links to that 2010 guidance for the use of ventilators based on the premise that the guidance that was issued by the state at that time called for the rationing and specifically recommended against the use of ventilators for people who had certain mental conditions, including dementia, which also implicated their age just due to the onset of dementia and the population that tends to suffer from that among the other conditions that were referenced. So on that basis, the state of Alabama was required to disavow the 2010 ventilator apportionment guidance and specify that it would not be in effect and remove any references to it from the website or websites that the state of Alabama was using that previously hosted that information. So to some extent, this is a case where there was some confusion, there was some kind of link rot where there is legacy information contained on a website that could be accessible through other sources, likely was found by a Google search by interested groups that made the complaint to the Office for Civil Rights. And having version control and being able to control digital assets could have avoided this in the first place and avoided any kind of confusion or the loss of confidence of individuals within Alabama with respect to whether their civil rights would be respected and observed in the apportionment of ventilators. There's no indication at this time that there have been any other kind of actions that were taken by the Office for Civil Rights. There might be future announcements forthcoming if similar cases are resolved. Otherwise, the lessons to be taken from this incident are to control one's digital assets, make sure that while it is good to store prior versions of documents just for archival and reference purposes, they shouldn't necessarily be available, and anything that is publicly available at the current moment in time, both now and going forward, should only be the most current information that's been reviewed by counsel so as to not create the impression that prior documentation and prior policies and procedures, which may no longer be compliant with relevant law, are in effect in controlling for a specific municipality, state, or other organization. Other action that's been taken by the Office for Civil Rights since the beginning of April has to do with HIPAA waivers, or more specifically, a declination to enforce the HIPAA rules that are in effect. For business associates, there was a change in an announcement of OCR's discretion on April 2nd, 2020. In that case, business associates were informed that the Office for Civil Rights would exercise their discretion to not pursue alleged breaches of the privacy rule that come from disclosures of information related to COVID-19 to public health and health oversight organizations. Now, normally, business associates could do this and make these disclosures without prior approval from the covered entity if it were allowed within the business associate agreement. And this is one of the terms that is permitted within the privacy rule to be addressed within the business associate agreement and to give the business associate discretion to make these disclosures with notification after the fact to the covered entity. What the exercise of discretion provides notice of is that pursuant to 45 CFR Part 164, Subpart 512, and further subsections B and D, business associates will not be subject to enforcement action for disclosures that are made to public health organizations and health oversight organizations. At the federal level, this would include the CDC and CMS, and at the state level, this would include analog organizations such as the Departments of Public Health, health districts, and also Medicaid administrators at the state level to the extent that they are involved with the administration of COVID-19 benefits and testing. The reason for this is to facilitate business associates sharing this information for testing purposes and so that the states can analyze what their needs are and where they stand in the crisis. As some of you likely have seen, the models for responses and resource consumption change on a weekly basis, and the information that is shared by business associates with the state organizations contribute to the changes in those models and the accurate projection of resource utilization. So on that basis, as long as business associates give notice to covered entities within 10 days after the disclosure of this information to a public health or health oversight organization, there's no basis for the Office for Civil Rights to seek to initiate any kind of administrative proceeding or enforcement action with respect to this disclosure, specifically to public health organizations and health oversight organizations by business associates. 1 week later, on April 9th, the Office for Civil Rights made another announcement with respect to testing and specifically community-based testing sites for COVID-19. This applies to both covered entities and to business associates. Significantly, it's retroactive to the beginning of the declared emergency. And this specifically has to do with these test sites that are administered by the covered entities and the business associates and have a relatively narrow scope of applicability. Now, while the privacy rule and the security rule are waived for these community-based testing sites in order to facilitate people going and receiving testing and covered entities and business associates providing their services to administer these sites, this doesn't necessarily mean that the OCR has advocated throwing out all of the HIPAA rules. It still advocates the use of the minimum necessary disclosure of information. And the guidance that was included within the notice of discretion provided some guidelines for how to run these kinds of community-based testing sites, specifically to use pavilions and to use other kinds of staging to protect the privacy of people who are receiving testing, and means to preserve the confidentiality of information that is obtained and shared in the administration of these sites. Now, specifically, the guidance does not cover everything that happens within the scope of the activities of these covered entities and these business associates within these community-based testing sites. Some of the examples that were provided are such as pharmacies that have testing that occur within their parking lots. Well, the activity in the parking lot is covered by this discretion to not enforce the privacy and the security rules. However, the activities within the pharmacy still are covered by all HIPAA rules and will be subject to enforcement action in the event of any breach thereof. Another example that was provided is a covered entity that's providing services to this community-based testing site and then creates medical records as a result of the activity at the community-based testing site. If there's a breach of those records that happens independent of what happens at the community-based testing site, that breach is still subject to the breach notification rule, and the failure to comply with that rule can still be the basis for enforcement action. Similarly, workers that are sent from one site, an example that's provided by the Office for Civil Rights is in a clinical laboratory. Anything that happens within that lab is still the basis or can be the basis for enforcement action based on a violation of the privacy rule, the security rule, but the actions that the workers take outside of the lab and at the site itself are beyond the scope of enforcement at this time based on this notification of discretion. So it's important to review that. It doesn't mean that the Office for Civil Rights has completely thrown out the idea of what HIPAA is and what it seeks to achieve in the administration of these sites, and encourages covered entities and business associates to follow the mandates of HIPAA wherever possible, especially to protect patient privacy with respect to this condition and the kind of potential stigma that is attached to COVID-19. But in order to facilitate the transmission of these services and to make resources available to the community, this notice of discretion has been issued in order to create a more accommodating environment for covered entities and business associates to come together and make resources available. And with that, I turn over my time to Christy and look forward to her update as well.
Good afternoon, everybody. This is Christy Kimball out of our Salt Lake City office, and just a few things that I'll cover very briefly. Just wanted to make sure that everybody was aware that the government has now said that pharmacists can participate in testing of COVID. They issued a statement this last week in regard to that. It's not clear, I'm sure in terms of how different healthcare systems are going to be utilizing pharmacists to conduct the COVID-19 testing will, be at the discretion of the various healthcare systems and state efforts. But pharmacists now can participate in that testing, and the government issued a statement saying that they will be given the same kind of immunity as other healthcare providers under the Federal PrEP Act. So that's the first item I wanted to cover. Just quickly, the second item is just mentioning that the government CMS continues to update blanket emergency waivers that they're allowing during the COVID-19 epidemic. So everyone should really be careful, be advised to continue to go to CMS's website, and I would keep that tab, open and refresh that, because they're updating these blanket waivers so much, and it's really good to make sure that you're aware of what federal waivers exist right now. To give an overview, I want to make sure that people understand how these work. There are federal blanket waivers that apply to federal programs like Medicare and CHIP. So CMS is issuing these federal waivers and flexibilities to allow the states and healthcare providers to respond more effectively to the COVID-19 pandemic. But then the states, or even certain healthcare providers, they can ask for additional waivers above and beyond those blanket waivers that already exist for everybody, for every healthcare system or provider out there. And if you go to CMS's website, they have a really nice overview of the various waivers and flexibilities that they've currently put in place. And then they have a list of for all the additional states that have requested additional waivers and what's been granted. They have links to those, and so you can see that pretty easily, and that's a nice thing to be aware of. The last thing is that even though you've got, and I know this is a problem and the thing that becomes kind of confusing, even though the federal government has said, let's say in regard to Medicare recipients and CHIP, they're saying, hey, look, we're going to allow for all of these various flexibilities and waivers right now. You still have state laws, right, that are in effect unless your state makes accommodations that are consistent with what these federal waivers allow, and then also what federal agencies are waiving right now, right? It's not just CMS. We've got Health and Human Services. We've got the DEA. We've got the Office of Civil Rights. We've got the FDA. We've got all these different agencies that are saying right now we're not going to pursue, action against, the following people for doing these things. We need it to accommodate. But there are still applicable and relevant state laws that we all have to think about. So just want to make sure everyone's kind of cognizant about that. States really are working to address that. I think Idaho's done a really good job in this regard, where the governor issued an order and it had 20 pages of state laws and rules that he was saying, look, we are going to accommodate and be flexible with the following state laws right now so that we can be in accordance with the federal guidance from the various federal agencies. And that's something in Utah that we're working on right now to try and get very consistent state laws and regs waived and accommodated. So I want to make you guys aware of that. On April 9th, CMS did issue updated blanket waivers. Just a really quick overview of what those are. And again, I would just mention that it's 20-something pages. I'm going to try and see how many pages that is. But the waivers right now that are in existence, there's 29 pages of federal blanket waivers that apply. And so there's a lot that they put in place to try and make sure that things are accommodated. But the additional waivers that came out on April 9th, and again, all of these are retroactive back to March 1st, but the updated waivers include that doctors can now directly care for patients at rural hospitals across state lines, if necessary, via phone, radio, online communication, right? So very, very flexible. And they can do that without having to be physically present. Remotely located physicians coordinating with nurse practitioners at rural facilities will provide staff at such facilities additional flexibilities to meet the needs of their patients. Additionally, nurse practitioners, in addition to physicians, can now perform some medical exams on Medicare patients at skilled nursing facilities. And that can be related to COVID or non-COVID activities, but they're just trying to make sure that patients in these SNFs can get the care that they need. And so there is an additional blanket waiver allowed there. Also, occupational therapists from home health agencies can now perform initial assessments on certain homebound patients, which allows home health services to start sooner, and it can free up home health nurses to do more direct patient care. And the last thing is that hospice nurses will be relieved of hospice aid in-service training tasks so they can spend more time with patients. But again, those are just a few of the most recent updates. But again, there's 29 pages of federal waivers that apply. Then you can look and see what state waivers, additional above and beyond these, have been provided by CMS. And then again, look to your state laws to see what's officially been waived by your states to make sure that you guys can function the way that you need to right now. The last thing that I would just mention is that with all of the states, there's so much, right, that has to be done to try and make everything kind of flush together between federal and state laws. But the one thing that's on the top of mind of most states, and you've seen some take action, is trying to grant some broad immunity for healthcare workers, for healthcare facilities, and even in some cases, it depends on the language of the order or the legislation that's being passed, but in some cases, even to individuals that, for example, may be sitting on certain hospital committees, making triage decisions, should there become a scarcity of equipment or resources about who's getting that care. So these broad immunity legislation or orders have gone through in several states. It's something that in the state of Utah we're working on. I know that Idaho's working on one as well. We're trying to work with various states, groups like the hospital associations, the medical associations, to push those through in a way, whether that's, again, the governor in Utah, there's probably going to be a special legislative session that's coming into session this week, so it may be via legislation, but trying to get some broader immunity in place for those individuals that are assisting with the COVID-19 response. And so you should really be looking to those soon, because that really should help, because I think there's a lot of concern about that. Most of these immunity statutes or orders that are being pushed through and signed increase the standard to gross negligence. So as long as healthcare practitioners and facilities are doing things in a manner, even if they're scrambling, a lot of bob and weaving going on, obviously, around the COVID-19 response. But unless you're grossly negligent, that's usually the standard that we're seeing in terms of where there could be some liability. But that's obviously a very low bar. And so look for those immunity provisions coming through at your various state levels, because I think those will be passed in most states. So with that, Kim, I'll go ahead and turn the time over to Kim Stenger to take up a few more issues.
Thank you, Christy, Jay, and Brad for all of those updates. All right, let's talk about that $30 billion payment that went out last week. Some of you may have been surprised when you looked at your bank account and suddenly had a lot more money than you thought that you were going to have in there, courtesy of HHS. That $30 billion payment is part of that $100 billion that was earmarked for healthcare providers under the CARES Act. The amount that each individual provider or each entity would get under that, as part of that $30 billion, depends on their share of the total Medicare fee-for-service reimbursements in 2019. So if you didn't get your check, or if you wanted to double check it or see what may still be coming to you, you can simply take the total amount of the fee-for-service Medicare payments that you received in 2019, divide that by $484 billion, and then multiply that by $30 billion, and that should give you your pro rata share of the money that should be coming to you. The electronic payments already were initiated. I know I received calls from multiple clients who suddenly received these electronic payments last Friday. Future payments may be coming out. For those providers who receive paper checks from HHS, will receive those payments within the next few weeks. As far as those who are eligible to it, the payment will go to individual or entity providers, including hospitals that are rendered services for COVID-19. It's paid to the entity that bills Medicare based on their tax identification number. So the payments are going to go to whatever entity that Medicare pays, not the individual providers necessarily, unless the individual providers are those who are submitting their own TIN for it. So it'll go to the entity. If you want to know where that money went to in your organization, you have to find out which is the entity, which TIN bills Medicare for those services. Now, when Administrator Berman indicated that this payment was going to go out without strings attached, well, that's not necessarily the case. As we found out as we've been going along, that there generally are strings that are attached, and this is no different. The CARES Act puts specific requirements for those entities that would be able to receive this. So the terms and conditions that accompany the payment include those CARES Act requirements plus some additional requirements. So let's talk about some of those requirements. First, within 30 days beginning today of the time that you receive that payment, then you've got to confirm receipt of the payments and agree to comply with the terms and conditions. The terms and conditions, there was a link in the email that you received that has those terms and conditions associated with it. The failure to return the payment within the 30-day period indicates that you have accepted the terms of the payment. If you don't want the payment, for example, if you can't satisfy the terms and conditions, then you're obligated to contact HHS within 30 days in order to arrange a return. You're supposed to be able to just simply attach or go to a link that's on the CMS website that would allow you to confirm receipt and agree to the terms and conditions. When I just checked a few minutes ago, I haven't seen that link yet, although it's supposed to be up and running by today, so we'll have to monitor that. As far as the terms and conditions, by receiving that money, you've got to certify certain things, including the following: that you billed Medicare in 2019, and that you currently provide the diagnosis, testing, or care for individuals with possible COVID-19. That is going to be a big issue for a lot of providers about whether or not they were actually providing diagnosis, testing, or care for individuals with possible COVID-19. That's the scope of what this $30 billion is designed to reimburse for, is those types of services. It's not for other unrelated services. So that raises questions about, well, what if you're a healthcare provider, maybe a podiatrist or other entity that really isn't involved in treating COVID-19, and you got that money? Well, you may not be able to keep it. Now, the guidance in the terms and conditions that we received doesn't really give us much direction concerning what they mean by currently provides diagnosis, testing, or care. But if you go to the government's website concerning provider relief, they have the following quote: "If you ceased operation as a result of the COVID-19 pandemic, you are still eligible to receive funds so long as you provided diagnosis, testing, or care for individuals with possible or actual cases of COVID-19. Care does not have to be specific to treating COVID-19, meaning that it still has to be COVID-19 related, but the person doesn't necessarily have to have COVID-19. HHS broadly views every patient as a possible case of COVID-19. Now, we're going to have to monitor the additional guidance that we get from the government in determining your eligibility for these types of payments. In addition to satisfying those criteria, you can't be excluded, excuse me, you can't be excluded from participating in Medicare, Medicaid, or other federal programs in order to participate in this fund. The funds can only be used to prevent, prepare for, and respond to coronavirus. And it can only be used to reimburse the recipient for those healthcare-related expenses or lost revenues that are attributable to coronavirus. Again, this is one that we're going to have to watch for guidance, how broadly that's going to be construed. How directly does it have to relate to the prevention, preparation for, or responding to coronavirus? What you may need to do is, until we get that further guidance, take the money that you receive from HHS and put it in a separate bank account. At the very least, you're going to want to make sure that if you haven't done so already, begin documenting those expenses that you've incurred relating to the prevention, preparation for, and response to coronavirus, so that if and when you're going to be audited, that you will have the documentation you need in order to track and support those expenses. The funds, that $30 billion, your portion of the $30 billion, cannot be used to reimburse expenses or losses that have been reimbursed from other sources, or other sources are obligated to make the reimbursement. So, for example, if you're getting other payments through the CARES Act, or perhaps loan forgiveness under the Paycheck Protection Program or the FFCRA or other programs, if you're getting those expenses, then you can't double dip. Again, we're going to have to watch for certain guidance. Some of the programs that are offered are loans. Well, in those situations, you'll have to repay the loan, so there is not necessarily, you're not getting reimbursed for those services, but we'll have to watch for further guidance. As we go along, you're going to have to submit reports to HHS as required. The government has said they will be issuing further guidance concerning the exact type of reporting that is going to be required. We do know that, however, if you receive more than $150,000 from COVID-19 related relief funds, then you're going to have to submit quarterly reports. And those quarterly reports are going to have to detail the total funds that you've received under the CARES Act or the Coronavirus Preparedness and Response Supplemental Appropriations, or FFCRA, or other acts. You're going to have to list the projects or activities for which those funds are used and the amount of funds that were expended for those projects or activities. So you need to begin accounting for where that money is going. Then the terms and conditions have a whole list of things that you cannot use the funds for. Most of these are politically charged issues like abortions, lobbying, human embryo research. Interestingly enough, you can't use the funds for capturing chimpanzees or human trafficking. Hopefully you did not earmark any of this money for those types of events. Now that covers the $30 billion that have gone out so far. There's still $70 billion in reserve that will be going out to healthcare providers under the CARES Act, but the government has said that they are working to target the distribution of the remaining $70 billion to those providers who may have the greatest need, including providers who are in areas that were hit hard by COVID-19, certain rural providers, reimbursements for treating the uninsured, and so forth. As I mentioned, I think that we're going to see, like with FFCRA and some of the EFLNA and those others, that we will get periodic guidance or interpretations or FAQs concerning these over the next few days or few weeks. So we'll want to make sure that you pay attention to those. Well, that was the big ticket funding item, but there were some other additional funding issues that came out this past week. Last week, I think Tim talked about the SBA loan and the Paycheck Protection Program. There was additional guidance that issued on April 6th concerning that. In addition, last week, the Federal Reserve unveiled a couple of additional programs, particularly their Main Street Expanded Loan Facility Program and their Main Street New Loan Facility Programs. We send out a client alert on those. Those would probably also be available for healthcare providers if you qualify in order to get those loans. We don't have a lot of the specific guidance. We just got generally the overall terms of those conditions, but not specific direction concerning how those are going to be implemented. A couple of other items that did come out. The government has issued updated EMTALA guidance. I don't think we talked about that last week. It specifically addresses such items as providing on-site screening for COVID-19. They generally confirm that you may direct, if a patient shows up at your facility and you've got an on-site screening location that's away from the ED, that you can direct that patient to that on-site screening location. Now, if you are maintaining an off-site screening location and you're a hospital, then the rules are a little bit different. The general rule is you can't send somebody from the hospital on campus to another location that's off-site for that screening exam unless that has been allowed under your state emergency preparedness plan. So you may want to make sure you work with the state to determine if you are going to run all of those through an off-site screening program, that generally you would need to work with your state to make sure that's part of the preparedness plan. If they just show up at your facility, then under traditional EMTALA analysis, you've got to provide an appropriate screening exam before you can send them away from the hospital. You're required to log in all of those individuals who show up to get that screening exam, no matter where they show up. They confirmed that you could use qualified nurses to help triage, or other qualified individuals with training in, for example, respiratory issues, to help triage those patients who come in for COVID-19, but that triage does not take the place of a medical screening exam. You've still got to do an appropriate medical screening exam, and that screening exam has to be performed by a qualified medical person. A qualified medical person is, as you know, a person who's identified in documents approved by the governing board, either some kind of a policy or bylaws that identifies the types of providers who are designated as qualified medical personnel who can perform the screening exam. If you want to use nurses to do that, if they aren't already identified in your bylaws or your other documents, then you could go ahead and pass some kind of emergency resolution by your board or other document approved by the board, some kind of policy for the board, but it needs to be approved by the board, identifying them as qualified medical personnel. The key here is make sure that whatever form of screening exam is being conducted, that it needs to be performed by a qualified medical person as approved by your governing board in order to satisfy EMTALA requirements. The government has confirmed that you may use telehealth in providing screening exams under EMTALA, but that telehealth has to involve a QMP. So, for example, if you want to isolate patients, you could provide the screening examination using telehealth, but this telehealth has to be done by a QMP. The government confirmed that hospitals could use drive-through testing sites for COVID-19, and they take the position that if it's just a drive-through testing site for COVID-19, that does, even though it's at the hospital, it doesn't trigger EMTALA because presumably the person is just coming in there for a test, not necessarily seeking emergency care. But if the person requests emergency care, even if they're part of that drive-through testing, then EMTALA would be triggered. They also confirmed that some hospitals are participating in community screening programs off-site away from the hospital. Just because the hospital participates in that does not trigger EMTALA liability. So if it's conducted away from the hospital and it's not otherwise a dedicated emergency department of the hospital, then EMTALA is not going to be implicated. If you haven't reviewed the EMTALA guidance and you're a hospital, I think that you probably ought to make sure that you go through and do that. Make sure that your COVID-19 responses are complying with the most recent EMTALA guidance that has come out. Finally, I wanted to touch base briefly about the OIG and fraud and abuse issues. As we talked about last week, the government did issue stark waivers that will allow hospitals and other healthcare providers to modify or enter into new financial relationships with referring physicians that address or are for COVID-19 purposes, and you can do so without violating STARK, even though the financial arrangement or the modification would otherwise violate STARK. In order to do that, though, you've got to satisfy certain criteria. Now, this week, the OIG said, remember that if you've got a STARK issue, you may also have an anti-kickback issue. The anti-kickback issue is enforced by the Office of Inspector General. This week, the Office of Inspector General issued guidance which said, if you have a financial relationship with a physician or a physician's family member that fits within these STARK waivers that CMS issued, then the OIG says you will be fine with us. We won't go after you for that, but you have to make sure that what you're doing is within the scope of those STARK waivers. That means that it can't be for purposes of fraud and abuse, that it has to be for a COVID-19 purpose as defined in those STARK waivers, and the financial relationship or the referrals have to fit within one of the 18 identified and approved arrangements that were approved in those STARK blanket waivers. All right, that is it. That is a brief overview of the legal issues that have come up in COVID-19 over the past week or so. We hope that these updates are helpful to you. We plan on continuing these as long as they are helpful. If you have questions, feel free to shoot any of us a quick email. Otherwise, we will plan on being back here next Monday for our next update. In the meantime, we hope all of you are well and staying safe and healthy.